Hi, my name is Al Penilla, and today we're going to bring you some information on Taiwanese prosecution based on U.S. patents and their priority documents. We have a very special guest today from Joe & Joe, patent offices from Taiwan, who will be presenting some information that we feel will be very useful and beneficial for the prosecution of strong patents in Taiwan. With that introduction, I'd like to pass it over to Joe & Joe. Thank you.
I have divided my presentation into three sections based on three questions that often confuse our clients. The first question is, can we make amendments based on the priority documents? The second is, can claims be amended based on the drawings? The last question is it a good idea to replace a full claim set with another? You might think these questions are simple and obvious, but actually their answers might be contradictory to your thought. Now let me start with my first question. Can we make amendments based on the priority documents? Before discussing this issue, I would like to share a real example with you. In this case, one of our clients asked us to file a patent application in Taiwan, and after filing the patent application, we received a letter from the client, and the part of the letter is shown in this slide. And the main point in the letter is that the two figures in the as filed documents provided by the client were wrong, figures 5 and 8, and the correct figures were shown in the U.S. priority application. So the client wanted to replace the wrong figures with the correct figures based on the U.S. priority application. The Article 43 of our Patent Act provides that any amendment should not exceed the disclosure of the as filed spec claims and drawings. Besides, according to our examination guidelines, the priority documents are excluded from the as filed spec and claims. So, based on these provisions, the answer to my first question is no. Amendments cannot be made based on the priority document. By the way, in the above example, although the wrong figures cannot be replaced with the correct figures based on the priority documents, we amended them according to the as filed spec. Although the priority documents are not eligible support for amendments, there is an exception provided in our examination guideline. If parts of the spec or drawings are missing from a patent application, and the missing parts are completely disclosed in the priority document, then the missing parts are allowed to be added into the patent application based on the priority document. For example, if there are only figures 1 and 3 in this Taiwan application, which means figure 2 is apparently missing from this application, and the figure 2 is clearly shown in the U.S. priority application, then we can add figure 2 into this Taiwan application according to the U.S. priority application. So, in view of the above, since any amendment shall not exceed the disclosure of the as filed spec, claims, or drawings, my advice is that all information about inventions sought to be patented should be completely and correctly disclosed in the documents you provide for us to file. And next, let's move on to the second topic. Can claims be amended based on the drawings? I know in the US there is no problem to do so. However, it is not necessarily the case in Taiwan, because there is a unique provision in the Patent Act. Specifically, in addition to the above mentioned provisions about amendments, the Article 26 of the Patent Act further provides that each claim shall be supported by the spec, and the examination guideline further explains that a claim only supported by the drawings does not meet the above provision. And therefore, if a claim is amended to include a feature only shown in a figure but not disclosed in the spec, then the amended claim will be considered violating this provision. Let's take a look at a real example. In this case, after receiving the first office action, the client instructed us to amend Claim 1 to include feature X, which was only shown in a figure. However, the examiner considered feature X cannot be supported by the spec and thus issued a final office action. As you may know, after receiving the final office action, claim amendments can only be made under very limited situations. So in order to avoid the above situation, we recommend that when making claim amendments only based on the drawings, the spec should be amended correspondingly. Now that I have talked about the second topic, and next I will move on to the last issue. Is it a good idea to replace a full claim set with another? Before discussing this issue, let's think about the following claim amendment. Canceling original claims 1 to 10 and adding new claims 11 to 20. And it is a common instruction from our clients, and this amendment should be very convenient for them. However, it may be the most expensive way for making claim amendments. Our basic examination fee is for a patent application having claim number less than 10. And for each claim in excess of 10, an additional claim fee will be charged. Besides, if the claims are amended, the additional claim fees will be calculated depending on whether an office action has been issued or whether the claims have been examined. Specifically, if the claim amendment is made before an office action, then the additional claim fees will be calculated depending on the actual claim number after amendment. On the other hand, if the claim amendment is made after an office action, then the additional claim fees will be calculated depending on the total number of the pending claims before the office action or the examined claims plus the newly added claims, no matter whether the examined claims are cancelled or remain in the amendment. In other words, even though the examined claims are cancelled in the amendment, they will still serve as the basis for calculating additional claim fees. Now let's see how the additional claim fees would be calculated in the above example. If this amendment is made before an office action, then no additional fee is required because the original claims 1 to 10 have been cancelled and the actual claim number after amendment is still 10, which does not exceed the basic claim number for examination. However, if the claim amendment is made after an office action, since the original claims 1 to 10 have been examined and the total number of the examined claims plus the newly added claims is 20, which is larger than the basic claim number by 10. Now you know why the above amendments is expensive. And for saving your cost, when making claim amendments, please amend the wordings in the present claims as much as possible, instead of cancelling the present claims and adding new claims. And finally, I would like to make a quick review by going through the above 3 questions. First, can we make amendments based on the priority documents? No. The priority documents are not eligible supports for amendment. Second, can claims be amended based on the drawings? No, not necessarily, because the amended claim must be supported by the spec. Third, is it a good idea to replace a full claim set with another? The answer is still no, since it's the most expensive way for making amendment. That concludes my presentation, and I hope this information is helpful and useful for you.
Thank you. I'd like to thank Stephen and Joe again for presenting on patent prosecution issues that creep up when prosecuting Taiwanese applications that are based on U.S. priority applications. If you like the video, please let us know by liking the video. Thank you.